Hello, everybody. This is Samantha from the Law Offices of Samantha Wolfe. Thank you for joining us for this month's virtual seminar. We try to do our monthly virtual seminars throughout the year. And today I'm excited because we're going to do a little bit different in our presentation as to how we do it. So let's go ahead. I'm going to start our presentation, Jess. If you want to go ahead and share the screen, that would be great. So the reason that we started doing these monthly seminars was that we wanted to have the opportunity to get our education and information out to clients in a way where maybe they felt a little bit more comfortable as opposed to coming into the office. So this is our office here in Waynesboro. This is our mission statement, which is why we do these seminars, just getting out information to our clients in a way in which they can go back and listen to the message and get any information that they missed the first time. So today we're talking about deeds, all deeds everywhere. So I wanted to start off talking about what are different ways that we can title a deed. So first there is tenants in common, and every category that I go under, there will be a subsequent slide. So there's tenants in common, joint tenants with right of survivorship and not as tenants in common, tenants by the entireties, and a life estate. So let's talk about tenants in common. I would say tenants in common are that's the most popular way that people hold title. And the reason is because you can have an equal or unequal undivided ownership between two people or more. So it's not as specific as to what percentage you have to own, how many people are on the deed. It does give you the ability to have unequal ownership percentages. And when you own it as tenants in common, when one owner dies, that deceased owner's share does go through his or her estate. It doesn't go to any of the surviving owners listed on the deed. We'll talk about that when we get to joint tenants with right of survivorship and why that's an important distinction. But just know that if you have it as tenants in common on your deed, then if you pass away, your share will go through your estate, usually through a will if you have one. If not, it'll go through Pennsylvania intestate law. Owning something as tenants in common may limit Pennsylvania inheritance tax because the way it's designed to is that one person would own a certain percentage, another person would own another percentage, and when one individual dies, you're only paying inheritance tax on that deceased owner's percentage of the property. So it does allow you to reduce the inheritance tax. It does result in probate because when one owner dies, their share does go through their will. And so that does mean that there would be probate. Now, probate in Pennsylvania just means that you go to the courthouse, you file some paperwork, you get sworn in as the executor, and then there are certain tasks that you have to do as the executor. But a lot of our clients that come in to meet with me express their desire to avoid the probate process, and that may be why they're retitling deeds a certain way. So know that if you own something as tenants in common, it will result in probate when one owner dies. In Pennsylvania, if the deed doesn't designate anything different, if it doesn't specifically say tenants in common, or if it doesn't specifically say life estate, then the default in Pennsylvania is tenants in common unless you are a married couple and you acquired the property after you were married. So if you were unmarried, purchased the property together, and then later got married, it doesn't apply to that situation. In that situation, you still own it as tenants in common. But otherwise, if a married couple does purchase property together, then they own it as tenants in common, tenants by the entirety, which we'll talk about in a second. The next thing is that different people can own different percentages. That's always nice to have that flexibility. All the tenants are liable for debts and taxes. That just means that everybody who owns a portion of that property is technically liable for debts and taxes on that property. It's also subject to a Department of Human Services Medicaid recovery. That means that if somebody was in a nursing home at the time they died, the Pennsylvania Department of Human Services could potentially recover against that real estate that's passing through your will. So whenever we have someone own it as tenants in common, we always like to make sure that they know that potentially that would be subject to Medicaid recovery if somebody would ever need long-term care. An example is if I owned a piece of property one half and my sister Jess owned the other half, when I pass away, my 50% ownership, my one half ownership interest will go through my will. Or if I don't have a will, it'll go through Pennsylvania intestate law. And if something happens to Jess, her 50% goes through her will or goes through intestate law as well. So we would each own 50%. Now we could also own it in different percentages. I could own 75% and Jess could own 25%. It just means if I die, 75% is going through my will. For her, if she would pass away, only 25% would be going through her will. It would also mean that if I passed away and I own 75%, Jess is only paying Pennsylvania inheritance tax on my 75% ownership interest. The 25% she owns is not subject to inheritance tax when I pass away. If she owns 25% and she passes away, then I'm only paying inheritance tax on the 25% that she owned. So when we talk about limiting the inheritance tax, that's what we're meaning, is that you don't have to pay inheritance tax on the entire amount. The second way that you can own property in Pennsylvania is joint tenancy with right of survivorship. So the example there would be if both Jess and I owned it and the deed actually said as joint tenants with right of survivorship. Now, remember, if it doesn't say anything, if the deed is silent and it just has Jess and I owning property in whatever percentages, then that means that we owned it as tenants in common. If, however, the attorney is drafting the deed and they put joint tenants with right of survivorship in the grantee clause, then that would mean that if I passed away, my interest would automatically pass to Jess. It wouldn't go through my estate. She would be then vested in 100% ownership interest. So the reason why people like joint tenancy is that it allows you to avoid the probate process and get it to that joint owner. A couple of things to remember about joint tenants with right of survivorship, though, is that there are 4 elements that are needed. The interest, possession, time, and title all have to be happening at the same time. That means that if my parents wanted to convey property to Jess and I, and they wanted us to own it as joint tenants with right of survivorship, the deed would have to be done at the same time. Jess and I would have to own the same percentage ownership in the property, and the titling would have to say that we would own it as joint tenants with right of survivorship. So we have to obtain the interest, our ownership interest, the possession of the property, all at the same time in order for it to be joint tenants with right of survivorship. Now, if Jess and I would own it as joint tenants with right of survivorship, and she would decide to convey her interest, maybe to her husband, as soon as she does that conveyance, that second deed, it severs the right of survivorship that we originally had in the deed. So you have to be really careful with joint tenants with right of survivorship. Sometimes you may sever that survivorship right without meaning to do it, simply because you convey somebody's interest onto somebody else. And because they didn't acquire it at the same time, then they can't own it as joint tenants with right of survivorship. Now, if Jess wanted to convey it to her husband and she still wanted me and her husband Josh to own it as joint tenants with right of survivorship, she could do a deed where she's conveying it to both myself and her husband, and it would say joint tenants with right of survivorship. Because we all received it the same day, Josh and I received it simultaneously, then it would still be joint tenants with right of survivorship. So the next block is just explaining that each owner must have the same interest in property. So here I can't own 75% and Jess own 25%. It has to be equal. So here we'd own 50-50. If our other sister, because I have 3 of them, so if my other sister was added onto the deed as a joint tenant with right of survivorship, we'd each own it in 1/3 interest. So it's based on how many of our owners there are divided by that proportion. So you have to own the same interest percentage. All owners must own an undivided equal interest. So that's, again, just reiterating that I can't own portion of a 50%. I have to own an undivided interest in the property. All owners must receive their interest at the same time. And if they don't, or if that person subsequently conveys it, then it severs that joint tenancy. They must acquire the interest with the same deed. So again, Jess and I can receive it as joint tenants with right of survivorship from my parents, but it has to be on the same deed that we're receiving that ownership. Otherwise, we don't own it as joint tenants with right of survivorship. My parents can't convey me half and then in a second deed convey Jess half and then try to say we own it as joint tenants with right of survivorship. It has to be on the same deed. At the death of the owner, the property automatically passes to the joint owner or owners. You don't actually have to do another deed there. What would happen is if I died and Jess is getting 100%, she doesn't actually need to do a deed until she passes away or until she's conveying the ownership interest. If I die, title automatically vests 100% in Jess. She does not need to do a deed as a result of my death. If she would then turn around and sell the property, what she's going to mention is just that I passed away, my date of death, and mention that the title vested 100% in her when that happened. That would be all she would need to do. Important thing to remember, though, is that Pennsylvania inheritance tax is still going to be levied at this time. So there's no probate, meaning nobody had to go to the courthouse, nobody had to convey anything through the recording of a deed, but there will still be Pennsylvania inheritance tax. So if I died, Jess, is my sister, is going to pay Pennsylvania inheritance tax at 12% on my 1/2 interest. If we go to the tenants in common, the previous slide, if I passed away, she'd be paying 12% on my 75%, if we use that as the example. But in this case, she's going to pay the 12% on 1/2 of the value because we own an equal interest in it. Joint tenancy with right of survivorship does avoid the probate process. So a lot of times parents will come in and say, we don't want our kids to have to probate, or maybe their child lives at the house with them. And so they want to go ahead and add their name to it. And so by doing that, it does avoid the probate process. It does not avoid Pennsylvania inheritance tax. And then lastly, the joint tenants with right of survivorship does avoid the Department of Human Services Medicaid recovery lien. So if I would be in a nursing home when I passed away, at my death, Jess, as my sister on the deed, gets 100% ownership in the property. The Department of Human Services can't try to recover against my share of the property because it didn't go through my last will and testament, or it didn't go through intestate law. Because I had the property owned as joint tenants with right of survivorship, they can't recover against the property. So that's another reason why some people do the joint tenants with right of survivorship, because we're avoiding the Medicaid recovery lien. All right, our next category is tenants by the entireties. And this is specific ownership between a married couple. And like I said, they have to have been married and then obtain the property in order for this tenants by the entireties to apply. The other thing to remember about tenants by the entireties, property may not be sold without the agreement of both parties. So in this case, I'll use Jess as an example. If her and her husband own a piece of property, Jess can't try to convey the ownership interest in the real estate because her husband Josh would also have to sign off on it because they own it as a married couple. At the death of the first spouse, in this case, if Jess would pass away, the interest vests at that point in Josh. No deed needs to be done. It's automatic. So sometimes I'll have a situation where husband and wife owned real estate and one of the spouses passed away, and the surviving spouse comes in thinking they have to redo the deed to take the deceased spouse's name off of the title. And you do not have to do that with real estate. What will happen is when the second spouse dies, or if the second spouse ever conveys the property, it'll just be a reference to the date of death of the first spouse in the deed. And that's all you need in order to be able to accomplish that. The default is tenants by the entirety for married couples, unless you state differently. So if my sister and her husband, Jess and Josh, didn't want to own it as tenants by the entireties, maybe they wanted to own it as tenants in common, they would then specify that in the deed. Because in Pennsylvania, if you are married, the default is you're taking title as tenants by the entireties. If you specify that you're taking it as tenants in common, then that just means that when one of the spouses die, their share goes through their will. And sometimes we see this with blended families where maybe it's a second marriage and they do want it to go through the will. They automatically don't want it to go to the surviving spouse because maybe they want their kids to receive their half. So I did have a situation where it was the second marriage. The one spouse did have adult children. The other spouse did not have any children, but they did have some siblings. And what they wanted to do is they wanted to take title as tenants in common. And when the husband died, he wanted his 50% interest to go to his kids. And when the wife died, she wanted her 50% interest to go to her siblings. And so in that case, although they were married when they purchased the property, we designated in the title, in the deed, that they were going to take ownership as tenants in common, and we were able to accomplish that. So although it's the default in Pennsylvania, you can deviate from the tenants by the entireties. This also does avoid the DHS, the Department of Human Services, Medicaid recovery lien. So in our example with my sister and her husband, if Jess would ever need long-term care and she would pass away while she's in the nursing home, if Josh is surviving her, it's not going to be subject to the Medicaid recovery lien because it doesn't go through Jess's will or through her probate estate. It goes automatically to our spouse. So therefore, the nursing home cannot recover against the value of the property at Jess's death. All right, Jess, let's move on to the next one. All right, the next one is a life estate. And I see this a lot with people as they age. We see it where the last one we did, I believe it was the wife was the surviving spouse, and she wanted to do a life estate deed where she reserved a life estate for her life in the deed, and then she wanted to have it automatically go to her children at death. And so she wanted to put that in the deed so it didn't have to go through probate. So what a life estate deed allows you to do is it does allow the owner to use the property while he or she is still living, with the property automatically transferring to the remainder beneficiaries at the death of the life tenant. So again, here it doesn't go through probate. It's something that automatically happens. That's why people like the life estate deed, because if the life tenant passes away, the deed does not have to be redone at that point. It automatically passes to the remainder beneficiaries in a life estate deed. It does avoid the probate process. The important thing to know about Pennsylvania with inheritance taxes is that in Pennsylvania, there is what they call the implied life estate. So whether you have a life estate in the deed or whether you don't and you've conveyed it to your children, but you're still living there, Pennsylvania is going to still tax your interest in the property because you are living there without paying any type of rent. Now, if you would pay rent, then we don't have to worry about the inheritance tax. But in Pennsylvania, if it's your primary residence, you're living there, and either you've reserved a life estate, or even if you haven't reserved a life estate, if you're living there without paying rent, it will be subject to Pennsylvania inheritance tax. And the entire value will be subject to an inheritance tax, not just the life estate portion. So although it avoids probate, it really doesn't cut down on any of the Pennsylvania inheritance tax. It's really just a probate avoidance technique that some families decide to use. It does protect the rights of the life tenant to reside at the real estate. So sometimes we'll have a situation where we have a client who might be elderly and they want to go ahead and avoid the probate process, but they don't necessarily want to convey the property to their kids at this point because they're concerned if they conveyed it to their kids, kids would evict them or not let them live there anymore. So it is a protective measure for clients that we use in those situations. There's no risk for a DHS Medicaid recovery lien because it doesn't go through the probate estate. It never passes through the will or the intestate estate. So therefore, the Department of Human Services cannot recover against a life estate deed. Now, the remainder beneficiary must sign any deed for sale. So if my parents reserved a life estate in their house but conveyed the property to me as a remainder beneficiary, I would be required to sign off if my parents ever wanted to sell the property. So you need to make sure that everybody understands that and is comfortable with that, because it does create some conflict potentially if the kids don't want to sign off on the sale and mom and dad do want to sell it. So you have to know that you do reserve your right to reside there, but it may mean that you need the remainder beneficiaries to sign off if you would ever sell the property. The real estate is subject to creditors. So let me explain that. So if sometimes clients will come in and say, well, I'll do a life estate deed, and if I need nursing home care, then I'm protected. What you have to remember is that that life estate is still subject to long-term care costs. And especially if that property is sold, the portion of the sale proceeds that would be allocated to a life tenant is still going to be available for long-term care or nursing home costs. So you want to make sure that you know that. The second thing about creditors is even though you reserved your right to reside at the primary residence, if you're adding a remainder beneficiary on to the deed, just like if you added them as a joint tenant with right of survivorship, the property is then subject to any of that newly added owner's creditors. So, for example, if my parents wanted to reserve a life estate and put me on the deed as the remainder beneficiary, their property is now subject to any creditors that I might have. If anybody sues me, if I'd ever get a divorce, anything like that, my parents' property would be subject to those creditors. If they wanted to convey the property to me and instead we're going to own it as joint tenants with right of survivorship, same thing. If I have any creditors, those creditors can attach to my parents' property. So anytime you are adding owners to a deed, you want to make sure that it's not jeopardizing your property and making your property subject to their creditors. And then lastly on this slide, we just have the property taxes are the responsibility of the life tenant. The life tenant really doesn't have all the control over the property. So you have to make sure that you're okay with all of those items before you agree to a life estate deed. I would say in our office, we typically don't do a life estate deed. And what typically deters people from doing it is the fact that they do lose some control. They can't just sell the property. And the fact that the property is subject to the remainder beneficiaries' creditors. Those two reasons seem to be enough of a deterrent that we don't do a whole lot of life estate deeds here in our office. Okay, so let's talk about the pros and the cons of adding children to the deed. So when we were kind of contemplating the seminar, what really drove us to pick this is that we have so many clients ask us about adding children to the deed. That's probably our most frequently asked question. Should I add my kids to the deed or should I transfer property to the kids? And so I always like to go over this because 90% of the time, once I go over the pros and the cons, the clients usually opt not to add their children to the deed or not to transfer property to the kids. So we want to go over all the pros and the cons so everybody's on the same page about what would be best going forward. So a pro would be that transfer of ownership would automatically happen upon your death. It's like we talked about all of these examples with the exception of tenants in common, the very first slide. If you would add your child as a joint tenant with right of survivorship, if you would completely transfer it to the kids, or if you would do a life estate deed where they're the remainder beneficiary, the benefit is when you pass away, it automatically passes to your kids. So it makes it so that it's not subject to probate and it's much easier to administer. So that's a good thing. It also, if you think about it, sometimes we have situations where families do have one child who either lives at the home with parents or who is providing a lot of the support for parents as they're aging and needing additional healthcare support. And so one of the things that we talk about is the fact that adding somebody to the deed does avoid probate. So if you had, for example, my parents' situation, 4 kids, and they wanted to deed the property to me because then that way it wasn't passing through the will. So their will has everything going equally to all 4 kids. But if they add me to the deed, the property would pass to me and it wouldn't actually go through the will. So sometimes parents want to do that because it's their way of making the estate equitable among the kids, whatever they feel is equitable. So that was the first pro. Second pro is it does allow your children to reduce the Pennsylvania inheritance tax unless it's a Pennsylvania applied life estate. But it does result in carryover basis. So let me flush out this a little bit more. So let's say that my parents purchased their property for $200,000 and it's now worth $400,000. And let's say they wanted to add me to the deed. What would happen is by adding me to the deed for income tax purposes, I get what they call carryover basis, which means that if I would go to sell the property once my parents passed away, my basis in the property would be the same $200,000 that they purchased it for. So if I sold it for the fair market value of $400,000 with the $200,000 basis, there would be $200,000 of gain there, and I would need to pay the capital gains rate, which right now is 15 or 20% depending on my adjusted gross income. I'd pay 15% of $200,000. Now, my parents would have avoided the inheritance tax by adding my name to the deed or transferring it to me, but then I would have to pay 15% on the 200,000 gain. If instead my parents waited and I received their property when they both passed away, I would have to pay 4.5% on the fair market value at the time of death, which is 400,000 in our example. But I would get a stepped up basis, which means that my basis in the property would be the fair market value of 400,000. So the sale price of 400,000 minus 400,000 means that I have zero capital gain for income tax purposes. So I paid 4.5% tax, but I didn't have to pay the 15% tax. So it actually worked out better for me to inherit it than it did for my parents to add me to the deed. Now, if I would know for a fact that I'm never going to sell the property and avoiding inheritance tax is appealing to my parents and I, then it might make sense to go ahead and add my name to the deed or transfer the property to me because I'm avoiding the 4.5% tax. And yes, I do get the carryover basis, but I'm not going to sell the property, so I never am going to realize that gain. So you want to make sure that when you're thinking about this, you're able to talk it through, whether it be with your attorney or with your accountant, to make sure that you aren't causing more tax for kids at a later date. And it might even be a higher tax rate than what you had thought. So you want to make sure that you're thinking through the income tax implications and the basis issues. So always feel free to ask your accountant or your attorney all of those implications. They should be able to answer that and even give you an example of what does that mean, so that way you aren't realizing something, or your kids aren't realizing something that they didn't anticipate because of them being on the deed or transferring the property to them. The last pro is that it does avoid the Pennsylvania Department of Human Services Medicaid recovery lien. And again, like we talked about, that would be if somebody would be in a nursing home at the time of their death. Because my name would be on the deed, it doesn't pass through the will. And so therefore, the Department of Human Services can't recover any long-term care benefits that they've paid for my parents because it didn't go through their will. So I wanted to make sure to bring that up. Let's talk about the cons. So there are more bullet points on the cons slide, you can see. So I want to make sure everybody understands what these are. So the first one is that your home could be exposed to your child's creditors. So in the example, if mom and dad add me to the deed, if I would be married and then get divorced, my divorcing spouse can now attach to my parents' property. And that would be for a divorcing spouse. That would be if anybody is suing me, anything like that where I would have a creditor. Having my name on their deed makes their property subject to my creditor. The second thing is that it may affect my qualifications for Medicare, student loans, and more. So sometimes we'll have a husband and wife come in and maybe they have a child who is receiving SSDI or SSI benefits. And so we always have to have a discussion about, well, if we add a child's name to the deed or transfer the property to them, is it going to jeopardize any type of benefits they would potentially qualify for? And that does apply to student loans. So if it's an asset that you have to disclose for any type of financing, you want to think through whether or not it makes sense for your child's name to be on the deed. The third negative would be if your finances are complex, it would leave both you and your child vulnerable to the foreclosure process and other concerns. So the basic premise here is that as soon as you add somebody's name to the deed, it is subject to their creditors. That would include if somebody was declaring bankruptcy or there was a foreclosure proceeding. And that then also applies if mom and dad would ever need to be filing for bankruptcy or have any type of foreclosure issues. It's then going to affect their child's credit as well. So you want to make sure you're thinking through that. The next bullet point is that Pennsylvania inheritance tax if the child predeceases. So we always assume that mom and dad are going to die first. And if so, it reduces the inheritance tax. But we have had a situation where the child has actually predeceased mom and dad. And then mom and dad are paying inheritance tax on their own house. And that's never what you want to do. You never want to have to pay tax on something that you already own and have already paid the tax on. So you have to think through, should I add my kids on? Because there is a risk that if somebody would predecease, if a child would predecease, you're going to have to pay a tax that you wouldn't normally have to pay on your own house. And then the last bullet point that's often overlooked is that this would be a gift for Medicaid purposes and there would be a look back period for it. So even if my mom and dad are going to add me to the deed and they're still going to own, and maybe we're going to own it as joint tenants with right of survivorship, adding me to the deed is still considered a gift for Medicaid purposes. And if my parents need nursing home care within that 5-year window after the transfer, that's technically a gift that could make it so they aren't eligible for Medicaid. So you have to make sure that you're thinking through that. For federal gifting purposes, the benefit is that you can gift 17,000 to as many people as you want every year. But for Medicaid, it's a lower threshold. It's actually only $500 per month. If you make a transfer over $500 per month, it's subject to the 5-year look back period. And again, that's even for the primary residence. So you want to make sure that you're talking to an attorney and thinking through, what is this doing for Medicaid eligibility for mom and dad? Am I potentially making it so that they won't qualify for Medicaid or so that there's a look back period? And from the child's perspective, it does make the child then financially responsible for mom and dad's long-term care up to the value of the gift that was transferred to them. So this is where we often, if mom and dad are considering wanting to transfer it, we might use a trust in this case, because trusts are a great way to make it so that the asset is not subject to creditors. It is not subject to then them coming back, DHS coming back. So there's a lot of benefits to using a trust. And we usually try to talk to our clients about that. It might be a better option than adding children's name to the deed, because then we're avoiding most of these cons. The only con we're not avoiding is that if you transfer it to a trust as opposed to adding your kids to the deed, there is still a 5-year look back period. So the look back period applies whether you gift it outright or in trust. But otherwise, the rest of these cons are taken care of by using a trust. So it's certainly an option that you can use. So when does a deed go through probate? So let's talk through that. So the first thing you have to do is verify the title on the deed. So if it's, again, owned by a married couple, then the default in Pennsylvania is tenants by the entirety. So it doesn't actually go through the first spouse's estate when they die. So you want to make sure you're thinking through that. Secondly, you want to check the deed because you may need to administer a trust or probate if that would happen. So I put this little note here because we actually had a situation where, for whatever reason, husband purchased property and it was after he was married, but he just put it in his name. And he didn't really even think about it. It was early 2000s when it happened. And by the time he came in to meet with me, it was 2018, so almost 20 years later. And when we were looking at the deeds, we realized that it was just in the husband's name. The reason why it was just in the husband's name is back in 2000, we didn't have the favorable federal estate tax exemption like we have now. That exemption is 12.9 million currently, which means each spouse has a coupon in the amount of 12.9 million. As long as your estate isn't exceeding that, then there's no federal estate tax. But back in 2000, it was a much lower exemption and we didn't have portability between spouses. Portability would mean that if my dad died and he didn't use his exemption amount of 12.9 million, my mom could attach it to her exemption and she'd actually be able to double the amount of the exemption. So back in early 2000s, we didn't have that. So attorneys would actually deed certain property in husband's name and certain property in wife's name, so that way there wasn't a tax when one of them died. The attorneys were trying to equalize the estate to make sure husband had a similar value as wife had, so that we weren't worried about the federal estate tax implications. But fast forward almost 20 years later, and we don't have that same concern because the exemption is so high and because spouses can group together their coupon as long as when the second spouse dies, it wasn't over 24 million, we're not worried about it. Or like it was in 2000, we did at one point have a lower exemption around $1 million. So we don't have to worry about that now. But the issue is that sometimes clients, when they did their deeds back in the early 2000s, they never redid them. So when husband and wife came in, my recommendation was just merely adding wife's name back onto the deed so that when husband or wife passed away, title automatically vested in the surviving spouse and you didn't have to probate the estate. So I wanted to make sure to bring that up because if we have folks that are listening that may have done planning in the early 2000s, late 1990s, they may want to revisit their deed and make sure, especially if you're married, that it has both husband and wife's name on there. The next bullet point talks about an appraisal unless selling within 9 months of death. So here I wanted to talk a little bit about when real estate goes through the estate of a decedent. There's a lot of questions about what the value of that is. So in Pennsylvania, you can actually take the tax assessed value and multiply it by the county's common level ratio factor. The common level ratio factor is a chart that the Department of Revenue releases every July. And on that chart, they give a number for each county. So, for example, Franklin County right now is 11.63. So, what that means is that I look on my tax card or my tax bill, I see what the tax assessed value of the property is, and I multiply it by 11.63. And that's going to give me what Franklin County considers is my fair market value for that property. That also applies when we're talking about adding somebody's name to the deed or transferring property. You can certainly use that to determine how much of a gift you're making by adding your kids' names to the deed or transferring the property to them. You don't always have to get an appraisal. So I wanted to make sure to bring that up. Now, if the tax assessed times the common level ratio factor is way off, either real high or real low to what you know the property would sell for, then you may want to get an appraisal because you always want it to be the closest value to what that property actually is. Because remember, if you're receiving it when somebody died, that determines what your basis in the property is. So if you sell it, it's going to determine how much gain you would have to pay on the sale proceeds. That's what our next bullet point is talking about, the tax assessed value and the capital gains there. So just remember that anything that gets disclosed on the Pennsylvania inheritance tax return or any return, an income tax return or the inheritance tax return, can be used to establish the basis in the property. And you always want the highest basis you can get so that if you sell it, there's less capital gains. And that's what our last bullet point is talking about, the inheritance tax versus the capital gains. 95% of the time, it is better to pay the inheritance tax and get the stepped up basis so you don't have as much capital gain. Now, again, that being said, we do have a couple of situations where children live with parents or maybe mom and dad have moved in and just have like a life estate portion of the deed. However it is, it may change based on if the child is planning to sell the property. But even if there's the smallest chance the child wants to sell, I always encourage people to think through what the capital gains would be. Okay, let's go to some hypotheticals. This is what makes this seminar a little bit more fun than our other ones because I wanted to actually give you an example of things so you can kind of understand. We're going to walk through the basis, whether it's subject to probate, whether it's subject to Pennsylvania inheritance tax, what it means for Medicaid purposes, what it means for federal gift purposes, and whether or not we have an implied life estate. So let's say we have John and Jane Doe, husband and wife. They live here in Waynesboro, and they're going to do a deed where they convey it to Jill and Jacob, their children, and they're going to convey it so that their children own it as joint tenants with right of survivorship and not as tenants in common. So let's start with John and Jane. What that means for them is that they're actually making a gift for federal gift tax purposes and for Medicaid purposes. So whatever the value of this property is worth on the day they sign the deed, that's the day they're making the gift, and they're going to want to file a Form 709, a gift tax return, disclosing the value of this property so that way we have it allocated that it's tax-free. There's no federal gift tax on it. The second thing that we think of gifting is that this is going to be subject to the 5-year look-back period because it's more than $500 in any 1 month. So for 5 years after John and Jane make this transfer is going to be subject to their long-term care costs. So how that would work is, let's say they signed it today, November 2nd, 2023. That means November 2nd of 2028 would be when they're out of the 5-year look back period. If they need care anytime between now and November 2nd, 2028, then it's going to be a countable transfer. So how it works when you go into a nursing home is you take all of the gifts you've made in the last 5 years, you add them all up, and then you divide it by the average monthly cost of nursing homes in Pennsylvania, and that will give you a figure. Usually it's the number of months that Medicaid is not available to pay for care, and you would have to privately fund your long-term care costs. So in this case, John and Jane, I would encourage them, if they really do want to do this, the sooner they do it, the better, because then they're more likely to make it through the 5-year look-back period without needing to care. Because they made a gift for federal gift tax purposes, if John and Jane survive signing this deed by 1 year, there will be no Pennsylvania inheritance tax for Jill and Jacob when mom and dad die. However, Jill and Jacob got mom and dad's basis in the property. So if they purchased the property for $200,000, that is Jill and Jacob's basis in the property too. If when mom and dad die, if they sell the property, whatever they sell it for, they'll subtract off their $200,000 basis, and that is what they will pay capital gains tax on. So they're going to get carryover basis. Probate, this does avoid the probate process because mom and dad have transferred it completely out of their estate, invested it in Jill and Jacob's ownership. Now, remember, if Jill and Jacob, if one of them would die as siblings, there will be inheritance tax because the deed says they own it as joint tenants with right of survivorship. So if Jill dies, then Jacob is going to pay, as siblings, 12% on 1/2 of the value. So you have to make sure in this situation that you're talking to not only John and Jane about the tax implications, but you might as well have Jill and Jacob come in too to the appointment and talk to them about what does it mean if one of them would pass away. It's available to their creditors because they're now the owner. And depending on if John and Jane are still living there and they're not going to pay rent to their kids, then it's still going to be subject to Pennsylvania inheritance tax under the implied life estate in Pennsylvania. So I think we covered basis, we covered the fact it avoids probate, we covered the fact that initially when they make the transfer, there's no inheritance tax if they survive it by a year, but if they're still going to live there rent-free, it's going to get pulled back in and be subject to inheritance tax. We talked about it's a gift for Medicaid. We talked about how it's a gift for federal gift tax purposes. They would need to file a 709 disclosing the value of the gift. And we talked about how if they live there without paying rent, it's still going to be subject to tax. Okay. I know I'm going through these really fast. Like I said, I'm happy to answer any questions at the end. We took these from real life situations that we have with clients. We thought that would be the best way. So in hypo number 2, we have John and Jane again, husband and wife. This time they're conveying it so that they own it and Jill and Jacob own it. And it's going to be joint tenants with right of survivorship. So in this case, they're still making a gift to Jill and Jacob of their interest in the property. So they're getting carryover basis in the property, but again, it's still going to be subject to Pennsylvania inheritance tax because their name is still on the deed and they're living there. So they'd get carryover basis, but because it's still included in John and Jane's estate when they die, they would get a stepped up basis. So that's a good thing there. Initially, they start off with carryover, but they will get a stepped up basis if it's considered John and Jane's primary residence. It does avoid probate because when John and Jane pass away, title automatically vests in Jill and Jacob. For Medicaid purposes, this would still be subject to the 5-year look back period, but it does avoid the Medicaid recovery lien. So if they would do a deed like this, adding their kids on, and one of them would need long-term care, when they both pass away, the Department of Human Services can't come back against the value of the property. And it would be a gift for federal gift tax purposes, so they would need to fill out a 709. Okay, hypo number 3. So this is a different family. We have Bobby Joe, he owns a third. We have Thelma Joe, she owns a third. And then we have Louise Joe, she owns a third. And so how they're going to convey it is that they're going to convey it to Bobby Joe and Mary Joe, husband and wife. So in this case, I'm assuming that Bobby Joe, Thelma Joe, and Louise Joe are all siblings in this case, because this is based on an example that we had here in our office. So in this case, when Bobby Joe and Mary Joe receive it, they're going to get carryover basis unless they're paying fair market value for their ownership interest in the property. So that just means that if they would ever sell it, they're going to have more capital gains that they're going to have to recognize for income tax purposes. It will avoid probate. So before they owned it, the siblings owned it as tenants in common. So if one of them died, it went through each of their estates. As soon as we transfer it to Bobby Joe and Mary Joe, they own it as husband and wife. So if one of them passes away, it automatically vests in the surviving spouse. No probate is needed. Inheritance tax, Pennsylvania has 0% inheritance tax between spouses, so no inheritance tax for that. It would be subject for Medicaid purposes. It's still in the 5-year look back period. So technically, Thelma Joe and Louise Joe made a gift. So if they need care within 5 years, it's potentially available for their long-term care costs. And then it is a gift for federal gift tax purposes. So Thelma and Louise need to fill out 709 gift tax returns informing the IRS of the amount of the gift that they've made. Okay, hypo number 4, which I think might be our last one. And I specifically asked Amy when she was putting the slides together, I specifically asked her to go back and pull this because this was an example we had where Bobby Joe and Mary Joe owned property. They were married, so they owned it as tenants by the entirety. And then what they did is they had 2 adult daughters that were living with them. And so they wanted to add their names to the deed so that if something happened to them, property automatically went to their children. But the issue here is the attorney who prepared the deed didn't pay attention to how the titling was working. So you're going to see that it says Bobby Joe gets a 1/4 interest. His wife, Mary Joe, gets a 1/4 interest. Thelma gets a 1/4 interest, and then Louise gets a 1/4 interest. But you're going to note there that it doesn't say Bobby Joe and Mary Joe owning an undivided 1/2 interest. Instead, they each own a 1/4 interest. So in this case, Mary Joe passed away. And so according to the way this deed would go, her 1/4 interest goes equally between Bobby Joe, Thelma Joe, and Louise Joe. So the way the attorney and the client had thought they had constructed the deed was that they didn't have to do anything until parents passed away, and then there would be inheritance tax. But the way the deed was worded, when Mary passed away, there was technically inheritance tax on 2/3 of her 1/4 interest. The share that went to her spouse, there's 0% tax on, but 2/3 of her 1/4 interest went to her 2 daughters. And technically, there's Pennsylvania inheritance tax at a rate of 4.5%. And so this is a situation where I had to tell the client, well, I know what you intended, but because the deed was not properly drafted, we have inheritance tax that we have to pay. And in this case, they didn't come in to talk to me until I think 2 years after Mary had passed away. So there's going to be interest and penalties that are going to be due on that as well because they didn't file an inheritance tax and they didn't pay the tax at that time. This still would result in carryover basis because Bobby and Mary Joe are conveying it to them and their kids. And so there's going to be carryover basis. They won't get a stepped up basis. It is going to avoid probate, but only in the sense that in Mary Joe's case, she passed away. If the deed had been properly constructed and Bobby Joe and Mary Joe owned it together as tenants by the entirety, there wouldn't have been probate. But because when the deed was prepared, the proper language wasn't used, it will have to go through probate because we needed an executor appointed for Mary's estate in order to be able to transfer the property to the other joint owners. It would be subject to Pennsylvania inheritance tax, like we talked about, because it wasn't properly titled in the deed. It would be subject to the 5-year look back period for Medicaid purposes, and it would be considered a gift for federal gift tax purposes, so a 709 would need to be filed. So I specifically use this hypothetical as our closing hypothetical because it's so important to remember that the language matters and you need to make sure that you know what the language means in the deed and that the attorney has properly explained it to you, because otherwise it has very unintended consequences that can really drastically alter what you thought you had to do when someone passed away. So I wanted to bring up this hypothetical just so everybody knows that they should just look at their deeds and make sure that it's deeded the way they actually want it to be deeded. If you're not sure, call the attorney who prepared the deed and confirm that what you think is happening is happening. All right, Jess, what else we have one more hypo. I was getting all excited. I thought we were done at 4. Well, we just saved the most fun for last. So this is hypo number 5. This is Autumn. So Autumn, in this case, I should have known. We want to do a life estate example. So Autumn is a life tenant, and then it's the remainder beneficiary is Summer. And so this is just explaining that Autumn is still going to live there. She has the right to reside there. Her daughter can't evict her from the house. But obviously when Autumn passes away, title automatically vests in her daughter. No probate. So it's still subject to inheritance tax, though, because unless Autumn is paying any type of rent there, Pennsylvania does have the implied life estate, so it would be subject to 4.5% Pennsylvania inheritance tax. All right, now are we done, Jess? Okay. So next month, December 7th, from 12 to 1, our virtual seminar is The Gift That Keeps Giving, the importance of a living will and the differences between a living will, a pulsed, and the 5 wishes document. I will tell you that we're specifically doing this presentation because my grandmother is in a long-term care facility, and we actually have run into some issues with there being some misconceptions between the living will, the pulse, and the 5 wishes document. And my staff can tell you when I'm talking to them in staff meetings about it, I get really animated and really passionate about this topic. So it was their idea. They said, let's put this in a virtual seminar. I'm going to try to keep my passion on simmer because it is something I feel like I find it very upsetting. I think that our elderly population is being taken advantage of. And I think that these documents, we need to make sure that we know what they have, that it's what they want to have, so that we're not taking advantage of them as they age. So that's why, to me, I get on my little soapbox about it, because I look at my grandmother and I see that, somebody came in, had her sign documents, and she didn't really understand what she was signing. And that was very upsetting to me. So that's going to be the next month. It'll be a wonderful seminar you all can join. So just email Amy, you can text, email her, you can sign up for the virtual seminar on our website as well. Okay, what I'm going to do now is I'm going to close this out, then I'll take questions once we stop the recording. So I just wanted to thank everybody for being on our monthly virtual seminar this month. Thanks for listening to me drone on about the deeds and how they matter. When we're coming up with seminar topics, typically we're looking at what we're seeing in at the office and things that maybe clients don't understand, or maybe things that were done incorrectly. So that's why we decided to do the deed seminar. Thank you so much for listening. You can always reach us at 717-655-2676, and we do official consultations. So if you have questions, you can always feel free to give us a call. All right, thanks everybody.